The broadcast is now starting. All attendees are in listen-only mode.
Good morning. Welcome. Thank you all for joining us this morning for the LifeLong Link series. My name is Nicole Seedorf, and I'm the Training Specialist for the Iowa Department on Aging. I have just a couple of housekeeping items before we get started this morning. First, we are recording the webinar this morning, and it will be available on our website at iowaaging.gov. And we have opened the webinar with everyone on mute. If you have any questions, please type them in using the chat feature or the questions feature as we go along, and we'll be addressing the questions at the end of the presentation. Our speaker today is Deanna Clingan-Fischer, who is the State Long-Term Care Ombudsman, and she will be speaking about issues within long-term care facilities. So thank you again for joining us, and I will now turn it over to Deanna.
Thank you so much. Glad to be here with you, and thank you to you hardy souls who are on the conference call the Friday before Labor Day's long weekend. What I thought I might start out doing again, and I'm not sure if I have the same participants on the call that I had a couple weeks ago when I spoke. So just a basic overview of who I am. As Nicole stated, I'm the State Long-Term Care Ombudsman. I've been in that role about 2.5 years. Previous to that, I have been with the department for 24 years, and I've served in various capacities as legal services developer as well as manager of a volunteer money management program. In that capacity, I've touched on issues such as elder abuse, financial exploitation, guardianship, conservatorship, powers of attorney, end-of-life care issues, Medicaid, Medicare. So what I feel that experience and those backgrounds have helped me help identify some of the issues and figure out some resources and resolutions for the residents and the tenants that we serve in our program. So I thank you for extending an invitation to have me come and speak and just give you some ideas of the types of issues that we encounter within the Ombudsman program. And I think you're going to find that these issues are encountered throughout the state by many people 60 and over and their family, not just by residents. By way of background, I thought I'd start out with a few slides as to who we are as Ombudsman, and we'll just keep, well, whoops, let me, what did I do? Sorry, just a moment, technical difficulty caused by Deanna. There we go. So I will not be in the box that stops the on air while I do that. And all right. So, who are we? Long-term care ombudsmen are advocates. We're advocates for residents of licensed long-term care facilities as well as for tenants of assisted living programs. We ensure that the rights of the residents in that setting are protected and that they are made aware of their rights, because many times residents and tenants are not aware of what they can and cannot do, and their rights to be able to lead a productive life within that facility or that program. So when you think of ombudsmen, think of rights, think of advocates. There are other long-term care facility players. For instance, the Department of Inspections and Appeals is the regulator of long-term care facilities, assisted living programs, elder group homes, and hospitals. And if you do encounter concerns that come through your phone lines by individuals who are concerned that a violation of law or rule has occurred, certainly a referral to the Department of Inspections and Appeals would be very appropriate. You can also always refer people to us. You know, think long-term care, assisted living. If it's an issue that we can't help someone with, we will certainly get them to the appropriate resource so they can receive the help they need or that they're willing to accept. The second player is Disability Rights Iowa. They are an advocate for residents with mental illness, intellectual, and other disabilities. And you'll see their phone number there. I think I'd like to make a clear distinction at this point that generally speaking, the separation that occurs for advocacy is between the Ombudsman program and Disability Rights Iowa. As I mentioned, DIA is a regulator, so they're not so much concerned about advocating for individuals, but looking for violations of law and rule. Whereas Disability Rights Iowa and the Ombudsman program, we are advocates, and we are advocating for what those residents and tenants want. Generally speaking, the DRI advocates for individuals within facilities that are primarily focused on mental illness, intellectual and other disabilities, whereas the Ombudsman program is an advocate for people who reside in nursing facilities, residential care facilities, assisted living programs, and elder group homes. And we advocate for anyone of any age who resides in one of those types of facilities. So that's my overview of the programs for the Ombudsman. I thought it might be helpful for the rest of this session together, really to break it down by rights. If you were with me the last time, I went briefly through the rights that exist for residents under federal and state law. And so through the rest of this presentation, I'd like to focus on each individual right and what does that mean, as well as then what are the issues that we see for that right, that particular right. So you'll see here on the screen, the first right I'm going to talk about is the right of citizenship. Because someone becomes a resident of a long-term care facility or a tenant in an assisted living program doesn't mean they give up their right to be a citizen of the United States. They have constitutional rights that still exist. They have the right to vote, to religious freedom, and to associate with whom he or she chooses. So what does that mean? The resident right to citizenship, voting. Residents and tenants have the right to vote. Even if they have a guardian. And with the election coming full cycle here soon, we have developed some fact sheets and some informational pieces that we will be sending out to all administrators and directors of assisted living to help educate them as to what the rights of residents and tenants are. And that will be available on our website as well if you'd like to get on and print some of those off for yourself and pass them out within the people you're serving. But voting is a big issue, especially when we have big elections. So we always help advocate on behalf of that resident and say, even if they have a guardian, because sometimes the guardian who's appointed by the court to handle health care and personal care matters, that guardian still believes at times that they have the right to control whether that resident votes or not, and perhaps try to figure out who they vote for. But it clearly is the resident's right unless they've been found in a separate legal proceeding to have incapacity to vote. So that's a big one we handle and deal with it a lot this time of year. They have the right to practice their own religious beliefs and to have visitors and to refuse visitors. So some of the issues that our office has been seeing within the realm of the right to citizenship is certainly that voting issue. As with a lot of older individuals or people who might need some level of care to the point where they go to a long-term care facility, people think sometimes they know better what's best for someone than the person does themselves. We always are advocating to say, no, it should be that resident that gets to choose whether they vote or not. And if they do choose to vote, it's their right to determine who they vote for. So then you get into issues of, well, I'm in the long-term care facility, I can't get to the polls, so we work with them to obtain an absentee ballot. Certainly family or guardians can be involved, again, trying to sometimes steer the ship as to who the resident might vote for. It can be very challenging at times to help implement this right, but that is certainly one that we see. And our goal, of course, is to, if that resident wants to vote and they request our help, we get them the help they need. And that could be through absentee ballot, that could be through arranging to get them to the polls if they'd like to go to the polls. Certainly we don't take them, but we can arrange for transportation to get them to the polls. And in overall ensuring that the process it has integrity, because what we don't want is people alleging that someone else voted through that absentee ballot, or that the resident purely really does not understand what they're doing, and perhaps they do meet the criteria for a separate determination of incapacity. So we want it above board. But ultimately, again, we want to verify that that resident has the right to vote if they so choose. Also, they have the right to religious freedom. That means they can attend services, they can have their pastor, their minister, their father, anyone who they would like to have visit them and conduct some type of religious ceremony with them is appropriate and should not be stopped. If we find out that it is being infringed upon, we work to remove that infringement. I know one of the questions that I got when I very first started was, you know, I am not Christian, so do I have to listen to the Christmas music that they play through the facility? Well, you know, that's a tough one. I did talk to Iowa, the Civil Rights Commission, and they said that is not an infringement of someone's civil rights, so they just have to be tolerant, and that's good advice for all of us. We need to be tolerant of other people's religious choices. Association and visitation is another issue we see. Certainly, I'm going to talk about this a little bit more in the upcoming slides, but I would say that's one of the bigger things that the local ombudsmen get involved in, and some of the most questions that I receive in particular is who can visit. And in some cases, you know, when you have a dire situation, that's when the dysfunction of a family or the resident support system comes through because you have instances where perhaps a daughter who's never liked her sister all of a sudden gets some type of legal relationship over the resident and starts making demands on the facility, or others saying, I've never liked her, I don't want her to visit mom. Again, we always go back to what is it the resident wants. You know, if the resident wants to see that family member, that daughter, we really advocate for that visit to occur. If the resident doesn't want to visit, then we advocate for that as well. You know, we will set that structure up and work with the facility to ensure that that doesn't happen. There are some exceptions, and I will talk about that a little bit later. But visitation, you know, who can come in, who can restrict who can come in, and when they can come in are really big issues that we see all the time. And then the other issue of leaving the facility. Again, I still have my constitutional rights of freedom of movement, so I can leave the facility to visit other people or to perhaps move to a least restrictive alternative. And certainly when I do have visitors, I can visit with them in private. So one of the next rights that a resident has is the right to respect and dignity. So what does that mean? Other than what you might think common sense tells you. Well, by law, it means that they need to be treated with consideration, respect, and dignity, be free from mental and physical abuse, punishment, involuntary seclusion, restraints. They have the right to self-determination. It should be the resident's choice as to whether medical care, treatment, visits, when they take a shower, when they eat, you know, those things should all be the right of the resident to make that decision on, and that's the self-determination component. Again, if you receive these types of questions or calls when you're answering a phone or when you're working with a client, feel free to, and there is some relevance to a long-term care facility, feel free to contact the Ombudsman's office. If it is someone that suffers from mental illness or has an intellectual or other developmental disability, certainly the Disability Rights Iowa can help with that, whether they're in a facility or in their home. And the other piece of that right is security of possessions. So I have the right to have my personal possessions with me and not fear that someone will be taking them from me. So what are some of the issues that our office sees with respect to respect and dignity? We see a lot of times people try to make decisions for residents and tenants regardless of what that resident and tenant wants. So in some instances, the resident and tenant is just very passive in that process. They're like, you know, whatever my family wants, whatever, you know, the facility says. But when we really try to talk with the resident or the tenant as to what they want, we find out that maybe they do want something a little bit different than what everyone else is trying to implement for them or on their behalf. And that goes back to that self-determination thing. You know, if someone has the right to make a decision for themselves, they should be the one making that decision, even if it's a decision that's not necessarily one that we would have made for ourselves or for them. If they have the capacity to make that determination and understand the risks, the benefits, the alternatives, and they still choose to go forward on that path, that is their choice and is their right. And that's one of the things that we encounter, I would say, on a daily basis, where individuals clearly are trying to be led into another decision than they would have made themselves. Another issue that very, very closely ties with what I've just said is going back to the respect and dignity issue. You know, when I'm speaking with a resident, I need to speak with the resident. I don't need to talk with their family. I don't need to talk with the staff about them in front of them. I need to really not act, and this is what we encounter a lot. We encounter a lot of individuals who act like that resident is just a statue. They're in the room, but they really can't hear, they can't understand. So we're going to make all these decisions about this person around them, but not really involve them in that process. And you know, that's a respect and dignity issue, because we really do need to not act like that resident can't hear or understand what we're saying, and in fact, we need to involve them in the conversation as the key partner in that discussion, not just as a bystander. And that is an issue we encounter quite often, and I think a lot of us who work with older people encounter that. It's called ageism, and where, you know, they're older, so they can't possibly participate in that conversation. Or it might not be someone who's older, it might be someone with a disability who's always been just, you know, whatever they want has been swept by the wayside. Another issue that we encounter, and I'm traveling with the local ombudsman, and one of them that we just encountered last week when I was with them in a facility is really the ability to afford privacy. You know, we walked by a room, there was someone who was laying in their bed without many clothes on, and anyone who walked down that hall could see that individual, and certainly they were not afforded privacy. Even if they couldn't understand that, the issue of residents' rights with respect and dignity and say that they need to be afforded the privacy. So we got, you know, we encountered staff and we asked them to help cover the individual and afford them a little bit of privacy, and perhaps that's closing the door a little bit. But whatever it might be, individuals have the right to not have some dignity when they're laying in bed or in the wheelchair, sitting in the wheelchair or at the table. And we can do, certainly that's one of the issues we see as ombudsmen. Allowing residents to do what they can for themselves, again, a big issue. It goes back to the self-determination. You know, if I can do something for myself, I should be doing something for myself, or I should be allowed to do something for myself. If I choose not to, that's a whole other story. But we don't want to act and dismiss individuals simply because they're in a long-term care facility. Another right is the right to privacy, and that goes through treatment, through interpersonal relationships, and through their personal and medical records. So what does that mean? It means that I have the right to have private and unrestricted communication with any person that I choose. It doesn't mean that I have to have that conversation in the middle of the lunchroom or in the middle of the nurse's station. It means that I should be able to have privacy when I communicate and meet with individuals. I also get privacy when I'm being treated. And that could be medical, psychological type of a treatment. Also regarding my medical, medical, my personal, or my financial matters or records. So again, that should be treated with confidence. So what are some of the issues that we see within this? Certainly, using a telephone has become an issue at some points. What we encourage individuals within the facility to do, if someone doesn't have a cell phone, is to really allow that person to have a secluded area for a private conversation. It shouldn't be at the director of nurses, the station, where all the activity and the hub of everything is happening. It should be in a spot, perhaps in their room or in a area that has been designated for residents to meet and have conversations. And that could be meetings in person as well as over the phone. They should have privacy in obtaining medical care. If indeed they have a resident or the resident has a roommate, the roommate should be removed during that time frame. Certainly curtains can be pulled so that in fact the treatment they receive is not seen by the world, so to speak, or seen by their roommate or other family members. Let's give them privacy when they receive medical care, as well as with their medical charts and information. They should be secure in a secure location, and I think HIPAA has helped a lot with that in ensuring that people are a little more concerned about the sharing and the loose lips of sharing medical information of other individuals. But those charts should be securely located. They shouldn't randomly be sharing information with family members or friends who come in about the health care of that individual unless there's a release by the resident or the tenant. So again, just keeping those charts, that information about the health care of that individual secure. Lack of confidentiality is an issue. We should not see staff or other residents discussing. Now, it's a little harder to stop another resident from discussing something, but if we've done a good job in helping them maintain privacy in their medical care, residents shouldn't know as much unless the resident themselves is sharing that. So again, it's just we shouldn't be sharing information with others without the release or the consent of the resident. That's just the bottom line there. And then sexual expression is the other issue we're seeing more and more about, and probably you've seen in the paper a lot about specifically sexual offenders reoffending when they are released to a long-term care facility. But even more generic and general than that is the right to maintain sexual relationships with individuals or engage in sexual relationships with individuals of their choosing, especially if that resident has the ability to consent to that conduct. So again, we work with facilities if a resident contacts us and has the desire to continue or create a sexual relationship. We work with the facility to ensure that privacy is maintained for that individual and that can occur. Another just generic issue for privacy is certainly helping educate individuals when you walk into a room. That is that person's home. That is their house. And so we need to knock before we enter. We need to ask permission before we just barge in. And so that's another education piece. People feel like they're in a public place, so therefore they should just be able to walk right in. And again, we always go back to that is that person's home. You wouldn't walk into someone else's home without knocking or seeking permission to enter. So another resident's right is the right to care. I always add to quality care. So what does that mean? That means you can choose a physician. I can choose the physician of my choice. I can determine, if I'm the resident, the course of that treatment and get reasonable accommodation for my needs and my preferences to meet the individual needs of the resident. So again, I get to choose, hopefully is what you're getting from that slide. So what are some of the issues that we're seeing with care? Certainly, when is it needed? and when is it responded to? And I think most of us hear about call lights. You know, if I need to get up and go to the bathroom, it would be helpful if someone responds to that need immediately so that I can be afforded respect and dignity. So that's one of the issues that we see on a regular basis. Decisions of the residents or is it someone else? Is it the resident that's being able to choose their care, or is it the attorney in fact under a power of attorney document? Is it the guardian? Is it a family member who really doesn't have a legal authority to make that decision? So we really work to ensure that even if there is an attorney in fact under a medical power of attorney or a guardian, that they continue to partner with that resident to deliver the care. And of course, you know, in some cases that may not be possible, but it's still a good technique and a practice to involve the resident in any type of healthcare treatment decision to the extent possible and feasible. But again, going back to that self-determination issue too, it should be the resident that's making that choice if they don't have a legal decision maker or a substitute decision maker like an attorney in fact or a guardian. And as you all know, powers of attorney for financial matters as well as for conservators can't be making care decisions anyway. That could only be a guardian or a medical healthcare power of attorney. And other issues with care is certainly talking about advanced directives, talking about do not resuscitate. Advanced directives in Iowa, really there's two forms of advanced directives. There's a durable power of attorney for health care, and there's a living will. The durable power of attorney for health care is an instrument that's signed by the resident when they have capacity. So if they don't have capacity, it's too late to sign it. So it's a legal tool that says in the event I can't make health care decisions for myself, this is the individual I'd like to make those decisions for me. It only takes effect at a point in time when I can't make those decisions for myself. So they call it trigger. The trigger is I can no longer make decisions for myself, and that determination is made by a doctor or a physician that says, yep, they can no longer make health care decisions for themselves. It's now appropriate for this attorney, in fact, to start making decisions. Just because I have a power of attorney for health care doesn't mean that the individual I've appointed can make decisions for me when I still have the ability to make those decisions for myself. And that's one of the issues we see on a regular basis. You know, well, I'm the attorney in fact, I'm the power of attorney, and then we'll look at the document and say, well, but it hasn't been triggered. There's no doctor's statement to show that she can't make decisions for herself anymore, and therefore she should be. And it goes back to that respect and dignity. We don't defer to someone who is named as an attorney in fact if, in fact, that document hasn't taken effect. So then, durable power of attorney. The issues we see are, you know, when does it become effective? Can the resident sign it? And if it's become effective, how do we involve the resident in some of the healthcare decisions to the best we can? The other issue is we really have to strongly remind people that healthcare power of attorney is just that. It's for healthcare decisions. It can't make other decisions like related to payment of to the facility or to visitation. It's really related to medical care and treatment decisions. So the other advanced directive I mentioned is a living will. In the living will document, again, you have to have capacity to sign it. So a lot of times people are recommending individuals sign it and they really don't have capacity. But if they do, they can sign this document. It's a directive to your doctor or to their doctor that says, you know, in the event I'm in a terminal condition, which includes persistent vegetative state in Iowa, so a coma, then I do not want life-sustaining procedures applied. So again, if I'm in that position and my heart or my breathing stops, they should not be trying to resuscitate me. That's basically what a living will says. My power of attorney for health care the attorney, in fact, should be able to make that decision for me if I am at a point where I can no longer make that decision for myself. And hopefully that attorney, in fact, is complying with that living will request. The other piece of issues with care is the do not resuscitate. A lot of people are like, well, what's a DNR? What's a do not resuscitate? Well, a do not resuscitate acts sort of like an advance directive, but it's not specifically an advance directive. What a do not resuscitate order is it is a physician's order that is signed, requested by the resident, and if the resident can't request it, it can be requested by the attorney in fact or a guardian. And it basically says, if my heart or my breathing stops, I do not want to be resuscitated. So I don't need to be in that terminal condition or that coma state that you are required to be in for a living will. The power of attorney, if there is, first of all, the resident can make that decision if they have the capacity. They request to their physician that they enter the order, and it goes into their medical chart in the facility. Most people, upon admission in a long-term care facility, are asked, would you like a do not resuscitate order put in your chart? And so that generally triggers the beginning of that process. An attorney, in fact, can enter into that. They can contact the physician and enter into that order just by doing that. A guardian, on the other hand, needs to go back to court and get a court order to be able to agree to a do not resuscitate order. So those are some of the issues that we really see within the issue of residents' rights relating to care. And sometimes it's just education more than an issue with the rights. People just don't understand these things, and they're not necessarily bad people trying to do evil things. They just don't understand the process. So the next type of resident right is the right to associate with any person of their choice and to uncensored communication. And I've touched upon this a little bit in previous rights, and which is a good thing when rights overlap on each other, because that just helps us clarify for others that these rights are very closely aligned and interwoven. So what are the rights for communication and association? To receive unopened mail, to receive or refuse visits from their physician, to receive or refuse visits from the Long-Term Care Ombudsman or from the Department of Inspections and Appeals, to receive or refuse visits from family, friends, and others of the resident's choosing, to receive or refuse visits from organizations, individuals who are providing social, health, legal services. So I think you're getting the sense that, hopefully, it is the resident's choice. If the resident wants to visit with someone, they should be allowed to. If the resident doesn't want to visit with someone, they should be allowed to not visit with them. What are the issues with association that we are seeing the most of? It relates to visitation. And I alluded to this a little bit, but there are a few limitations as to and exceptions to my broad stroke of it's the resident's choice, and which we'll talk about in the next slide. But in essence, visitation has become a big issue for us, and most times it's because families feel that someone is trying to visit with the resident and take advantage of them, or it's a family issue where, as I mentioned before, I become my mom's attorney, in fact, under a healthcare power of attorney, or I'm her guardian, and all of a sudden I decide, I've never really gotten along with my sister, I've never really liked her relationship with my mom, so I'm just going to blanketly say she can't come and visit mom, regardless of what mom really wants. And so we see it used as a tool to continue perhaps years of conflict within that family. Again, people aren't looking at what's in the best interest of that resident, they're looking at what's in their best interest, or how can they get back at that person. We get involved in many of those situations, and in fact, our office has developed a policy which states that under the state law, our view and our interpretation of the state law is that an attorney in fact under a durable power of attorney for health care cannot make visitation decisions, because it goes back to it's not a health care decision. Whether someone visits or not is not a health care decision. It's not a treatment decision. There are sometimes legitimate reasons as to when someone can or cannot visit, and we certainly have that discussion. We try to be reasonable with it. But again, we're always going and talking to the resident. What does that resident want? What do they want? Not what does everybody else want for them? And there are also the issues relating to visitation are what time? When can a visitor come? You know, and the law says it needs to be a reasonable hour. So that's not really determined or defined, but a resident can have visitors at any reasonable hour. So it doesn't mean that they can't come at 10 o'clock. It doesn't mean they can't come at 6 a.m. It really needs to be convenient, however, for the resident. So I've mentioned a couple times that there are limitations or exceptions to when visits can happen. And those limitations are set out as follows. Certainly, if the resident refuses to see the person, then that's it. The visit doesn't occur. If the resident's physician documents the specific reasons why such a visit would be harmful to that resident's health, you know, they're very agitated after the visit, they become very aggressive after the visit, they have some type of depression after the visit. You know, if there are some medical symptoms that occur from that visit, certainly we don't want that visit to happen either. But it's not good enough to just say this is the case. There needs to be some type of documentation by a physician to show that that visit is harmful to the resident's health. And then the other instance where a visit can be limited, and these are all by the facility, is when the visitor's behavior is unreasonably disruptive to the functioning of the facility. So a visitor comes in displaying a gun, or has been known to push or hit people, or just to be verbally assaultive or abusive to other residents or staff. Certainly the facility can decide that this person is disruptive to the functioning of our facility, and we are not going to allow them to come into the facility. Now, our issue when that happens is, are there ways that we can then, if the resident truly wants to visit with that person, are there ways that we can help that visit occur, perhaps maybe outside of the facility or through supervised visitation during that time frame? So again, those are the limitations in law which state that a facility can deny visitation if one of these categories is met. What are residents' rights? Again, the next one is the right to personal property and to manage their own finances. What does that mean? It means they can decide what they wear. They can manage their own financial affairs. The facility cannot require them to turn over all of their money and resources to them. They can have personal belongings in their room, and if they do have those belongings or money in their room, that they have the right to be secure in the possession, meaning they don't need to worry about theft, or they shouldn't have to worry about whether they can access the funds. If they do allow the facility to hold on to their money, they should be able to access their funds when they want them. Some of the issues that we see, certainly accessing to personal needs funds. Some facilities can be the representative payee. So that means the Social Security, the personal needs allowance goes to the facility. If the resident would like $5 because they're going out with friends, or they're going to the hairdresser and they'd like a $20 bill, they should be able to access that money when they want it or need it, not wait a period of 5 days. So that's something we work on behalf of residents to help them with. Clothing, they have the right to their clothing, do not have it lost or destroyed. Certainly I mentioned the representative payee issue. If indeed Social Security or any federal benefit agency determines that the payee, that this person cannot handle their benefit check, a representative payee can be appointed. In some cases, that can be the facility. So that they are on the bottom of the list, but it is possible that sometimes that's the only entity that's available to help that person with their needs. And there are very strict guidelines in place by Social Security as to how the facility can allocate that fund. And certainly we see issues of misplaced personal property. You know, where'd that ring go? Where'd the medication go? And I know that's not personal property, so to speak, but where'd that shirt go? So a lot of issues of, when you're in a communal type setting, it's sometimes difficult to keep things, make sure people get their personal property back, but we certainly help them if they do lose a piece of property. One of the other rights is the right to information and to participate in treatment decisions. And I've broken these down to deal with information first. Certainly, they have the right to learn about the services and the charges that they will be incurring or receiving before they're admitted. They have the right to get the facility rules as well as a copy of their rights once they're admitted. Contact information for our office, for the Long-Term Care Ombudsman's office, have access to survey reports, plans of correction, if the facility has been cited for something. They have the right to be notified if their room is going to be changed or if they're going to be receiving a roommate or their roommate's going to change, and receive all of this information in a language that they can understand. What are some of the issues with information? Certainly, people may receive the information, but they're receiving it at a very emotional time. They're receiving it upon admission, if they're receiving it. In some cases, I go back to that self-determination issue. It's the family member that's receiving it or being told all of the information while they're putting the resident in the room, that type of thing. And so you might question whether the resident actually received it or if it was a family member. But back to the very beginning, you know, at the time you're being admitted to a long-term care facility, it's a very emotional time for not only the resident but family and friends that might be there with them. And so that's when they're getting all this information as to what are the services, what are the charges, what are their rights. And ideally, a family would be looking around at facilities and obtaining that information beforehand so that they can actually make an informed decision before just taking someone and admitting them. But it's not necessarily the best time to be receiving information. And it's confusing at that time. It's a lot of information presented at a time that's already emotional to begin with. So people may receive it but may not understand it or remember that they received it. What are their rights to treatment decisions? Again, that's to be fully informed of their medical conditions. You know, we're not going to hold it back from them just because it's uncomfortable for us. They need to be able to participate in their own assessment, their own care planning or care plan development, and the treatment and discharge. They can refuse medication and treatment. They can refuse restraints, and that's both physical and chemical restraints. And they have the right to review their own medical record. Some of the issues that we get involved with when it comes to treatment decisions is who decides? Who's deciding this? Is it the resident? Or is it a family member? Is it facility staff? Is it a legal decision maker? Again, we always go back to it's the resident's decision. And of course, even if there is a legal decision maker like a healthcare power of attorney or guardian, they should be working in consultation with that resident so they feel like they're a part of the process, if at all possible. Medical advice or an order, we have a lot of instances where people will say, well, the doctor has an order. The doctor says that they need to do this or that. And, you know, that really is not the doctor's choice, just like with all of us. You know, the doctor can tell us you need to stop smoking, you need to stop eating, you need to lose weight, you need to take your medication for high blood pressure. But we all have the right to say, yeah, we probably should, but we're not going to. The resident has that same right. Just because they're in a long-term care facility doesn't mean they have to abide by every order. The issue will be, you know, the facility will be charged with trying to fulfill that order. And so if there is indeed an order, we need to get all on the same page and have the facility document within that file to show that they really are deferring to the resident and it is the resident's choice, so that they're protected as well if they do try to follow the resident's right to choose versus following the order. And always, always, always we encounter people who don't really quite fully understand the difference between capacity versus competency. You know, certainly capacity is what can I do for myself, so both physically and what do I understand mentally. Competency is a legal determination. Competency is only determined through the court system, through a guardianship or a conservatorship proceeding. And so we need to help educate people to stop using those terms interchangeably. The next right, and I know I'm getting close to my time, but the next right is the right to due process and discharge. What does that mean? It means that they can remain in the facility unless it's necessary to, they need to go somewhere else, like a hospital or from assisted living to nursing facility or skilled care. So it's necessary to meet their welfare. If their health has improved, they should be going to a less restrictive alternative or back home. If it's necessary to protect the health and safety of others, then they can be discharged. Or if the resident has failed after notice to pay for their care in the facility can issue a discharge. If discharge meets one of these criteria, then due process has to be afforded. So one of the criteria we just mentioned. And what is due process? That means that they have to give notice of the transfer or discharge. The resident or the tenant have the right to appeal that notice. They are given the contact information of our office, the Long-Term Care Ombudsman's office, and we can assist that resident with the appeal or finding other alternatives if that is their desire. And in all issues, the facility cannot discharge that person unless they have some type of order or plan in place for a safe discharge. They can't just leave them out in the street. What are some of the issues with residents? Of course, we see people being discharged because the facility feels that they are not at a level of care that they can handle, so they might transfer them to the hospital and then issue an emergency discharge and says, we can't handle them, we can't handle their needs, we're not taking them back. Certainly we see notice provisions that are not compliant with law, so we will educate the facility that you have to restart the 30-day process because it's in violation of law. We find sometimes that there are attempts made to discharge people even when that criteria is not met. For assisted living, evictions are allowed because the landlord-tenant law applies, and evictions are allowed in landlord-tenant law. And within closures, of course, if a facility is closing, it's very difficult to assert rights for the resident to stay there because the facility is not going to be operational. And we've had a lot of closures of recent of residential care facilities in particular. The right to be free from abuse, neglect, and exploitation, chemical and physical restraints, neglect. What does that mean? It means that they need to receive adequate and appropriate care, be free from charges for services that are covered by Medicaid and Medicare, certainly to be free from mental and physical abuse, punishment, involuntary seclusion and restraints, as well as have their property secure. What are the issues that we are seeing within abuse? And I'm sure you're getting or hearing the same types of things in the calls and with the clients you work with. most people think if they're in a facility, it must be the staff that's doing the abuse or the neglect, and certainly that exists. But we're also seeing a lot more issues of family members that are coming in and financially exploiting that resident, meaning they're not paying the bill, and therefore the resident is close to discharge because the family has decided to spend the money on themselves rather than on the care of the resident. It could be misuse of funds by the fiduciary as well, and the fiduciary is someone like a representative payee, financial power of attorney, or a conservator or a trustee. So perhaps they have a fiduciary duty to meet the basic needs of that person, but they're not. So we're seeing a lot more financial exploitation by family members or by fiduciaries. Certainly another issue we see is neglect, where they're not meeting the needs of the person. They're not responsive to their request for assistance or their call light, as well as sexual abuse. We're getting close to the end here. So we've got certainly one of the last rights is to voice their concerns without fear of retaliation. So they have the right to present grievances without fear of reprisal. Prompt efforts of the facility to resolve those concerns. They have the right to complain to us, the Long-Term Care Ombudsman Program, to DIA, and if they do have concerns, they have the right to also formalize a resident council so that they can sit and talk about that. What are some of the issues with that? Certainly we see, the reality versus the law. So the law says they need to be free from retaliation. The reality is people are very fearful. I'm in this facility. I have to depend upon these people to provide care to me. I don't want to rock the boat. I don't want to rock the boat as the resident, and as a family member, I may not want to rock the boat because I'm afraid that if I do, my family member will be treated differently than they were before. So that's a very real fear by people, and it exists, so we have to be aware of it. Certainly, it's intimidating. And they're fearful as well that not only if they if they do complain about something, that they may be discharged or evicted. And it ultimately gets down to, this is a he said, she said, or she said, she said, or he said, because it's the resident saying you do this, the staff saying I don't do this. So, at a certain point, there's perhaps not proof or there's lack of documentation that the issue or the concern that's verbalized is reality. They have the right to apply for state and federal assistance without discrimination. So what does that mean? A facility cannot require a minimum entrance fee to stay if the stay is going to be paid by Medicaid or Medicare, and they need to inform the resident if it gets to the point where they might be eligible for Medicaid or Medicare, how they go about applying for that, how they can obtain a refund if they've overpaid for their stay because they're being discharged, and that they don't need to require a responsible party. The issues we're seeing, certainly within Medicaid, the applications and processing are taking time within IME or DHS. What we see is a lot of facilities do ask for a responsible party, and by signing as a responsible party, you're basically saying, I will pay for this person's care if they can't afford to do it themselves anymore, or if Medicaid or Medicare is not an option. Certainly one can be a responsible party or someone who's contacted in an emergency situation without taking on personal liability for the bill. Even if I am the attorney in fact or the guardian or the conservator, what we encourage people to do is you can certainly sign as a responsible party because legally you are, but sign in your official capacity. Don't sign personally, because if you sign Deanna Clingan-Fischer as the responsible party, I am personally responsible. But if I assign Deanna Clingan-Fischer as guardian or as attorney in fact, I'm only signing in my fiduciary capacity, and I cannot be held personally liable for that bill. And again, that's some education we do for people. And then really the last right that I wanted to talk about is the right to be fully informed. And in fact, that intertwines with many of the other rights I've already talked about and the issues we see. Certainly knowing what the charges are, what are my rights, who can I contact if I have concerns, what are you being fined and cited for by DIA, and getting all of this information in language I understand. Again, understanding the admission or occupancy agreements before they are signed. People have the right to take them to an attorney, to have them reviewed, to see if they actually do protect your rights or if they're overstepping. Many admission or occupancy agreements require the resident or the tenant to enter into arbitration if they do have a conflict or a concern with that facility. And we encourage people to really look at that clause to determine, is this a good fit for me? And if it's not, then perhaps try to negotiate that out of the contract. Questions to ask, what happens if I do need a higher level of care? And the other question we're seeing is relating to pre-admission screening and resident review, the PASAR. If it's determined that someone does need specialized services, are they getting them? Or if the PASAR comes back and says they don't need that level of care and they want to stay there, then we will advocate for that individual to stay there and help them with the appeal. So in a nutshell, that was a really quick and dirty account of some of the rights and issues that we see within the Ombudsman's office. I know we don't have too much time for questions. Certainly, if you have questions, I'd be happy to field them. But if you don't and you'd just like to email me separately, I'd be happy to respond in that fashion as well. You'll see our contact information and my specific email is listed there. If you'd like a copy of this PowerPoint or have questions after the fact, I'd be happy to field those. So thank you again for your time and listening to me. I truly appreciate that.
Okay, I will look and see if there are any other questions, or doesn't look like we've had any questions submitted. So this concludes our presentation on issues within long-term care facilities this morning. Again, the presentation will be available on our website at iowaaging.gov in approximately 1 week. Thank you for joining us this morning, and please enjoy the remainder of your day.